It's time for FLA Law, brought to you by the personal injury attorneys of Perinick, Caulfield, Averill, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Back live, and you are listening to FLA Law, hosted by the attorneys over at Perinick, Caulfield, Averill, and Noyes. Tonight we are doing another call-in show where you, the listeners on the radio here, can call in and ask us legal questions, and we will do our very best to answer them. And we are back by popular demand. For those who don't know, the firm of Perinick, Caulfield, Averill, and Noyes used to host a show on a cable TV format many years ago, but we decided to switch this time and switch it up and go to radio. So before I get into it and give all you listeners the call-in information, let me first introduce the attorneys we have here in the studio. First off, my name is Daniel Havican. I'm an associate attorney over at Perinick, Caulfield, Averill, and Noyes. I practice in personal injury, workers' compensation, and social security disability. To my left is Matt Noyes. Matt?
Good evening. Yes, it's Matthew Noyes. I am one of the partners at Perinick, Caulfield, Averill, and Noyes. A long time ago, I used to host the TV show, and as I aged, my face became more for radio than TV.
And before I introduce the young woman over here to my right, let's talk a little bit more about the history of Perinick, Caulfield, if you don't mind, Matt.
Sure. Guy Perinick and Frank Muscarella really started the law firm back in 1955. Guy decided that he didn't want to be an insurance adjuster anymore, and he wanted to wear the white hat instead of the black hat, and also decided that he was just going to serve the people and specialize in personal injury. So he and Frank started up the firm downtown Clearwater back in 1955, and very soon thereafter, Bob Carroll joined, and Bob was a partner for a very long time. He has since retired and enjoying his family and grandchildren, and the firm just kept growing and growing and growing. We've been serving Tampa Bay. We are the oldest personal injury law firm in Tampa Bay, and we've been around since 1955.
Yep, and we got about 6 attorneys there now, and one of them is to the right of me here. Jacqueline, you want to introduce yourself to the listeners?
Sure. Good evening, everyone. And for everyone that's looking on Facebook Live, I'm waving. My name is Jacqueline Bryant. I'm also one of the partners over at Perinick, Caulfield, Averill, and Noyes. I have been there just about 11 years now. And I, too, also specialize in personal injury law, workers' compensation, car accidents, premise liability, and also social security disability, as we all do.
Yep, very cool, Jacqueline. And you mentioned it briefly there about the Facebook Live. Do you want to tell the listeners a little bit more about that and a little bit more about the socials that our firm has and ways to contact us or find us?
Absolutely. So as you are joining in, listening, if you want to look us up on Facebook, we are Perinick, Caulfield, Averill, and Noyes Injury Lawyers. That's how you find us on Facebook. Perinick is spelled P-E-R-E-N-I-C-H. Essentially the same on Instagram, but it may also be PCAN. So you can try searching that because that's what it is on TikTok, actually. If you look for us on TikTok, it's PCAN, and that's short for Perinick, Caulfield, Averill, and Noyes Injury Lawyers. So that's kind of how you find us on the socials. But of course, if you search PERENICH Perinick, you'll find our firm, Perinick, Caulfield, Averill, and Noyes. We are streaming live right now on Facebook. So if you would like to ask a legal question and you prefer not to call into the radio, you can actually leave a comment right now in the comment section or the chat part of the live stream. And Daniel will be able to see your questions, and we'll be answering those live on the air tonight.
Yep. And the call-in information for you listeners who want to hear your voice on radio, you can call us locally at 727-441-3000. Again, that is 727-441-3000. For those out of the Tampa Bay area, you can call us toll-free at 1-866-826-1340. 1340. Again, that is 1-866-826-1340. And as Jacqueline mentioned, I have the Facebook Live right here in front of me. I'm looking at all the comments. I can see all the comments. If there's legal questions, we're here for you.
Right, but it makes it a lot more fun this hours if people did call in or write questions on Facebook. So,
oh yeah, absolutely.
Yeah, so call us.
Yeah, I
We're
mean,
we
ready.
lawyers love to answer questions.
yeah, I mean, we also like to hear ourselves talk. So.
Yes. And how often do you get 3 attorneys available to answer your questions for free? So that's pretty good.
Sure. And while we have the time, while we're waiting on some listeners to call, why don't we talk a little bit about some of the crazy things that have happened in the Clearwater area the last couple of days. And unfortunately, they are sad, but it has happened, and it kind of turns its head on personal injury in a little respect, because a couple of days ago, he was 55 years old, but he was a young man, and way too young to die. He was a construction worker, and he actually got hit and killed as he was flagging down traffic for the Gateway Expressway project that's now being built over in the Clearwater area. So very sad, but I know Matt wanted to talk a little bit about Florida's move over law.
Right. And actually that plays a role in that accident as well. But not only was there a crash there was, I think it was yesterday, maybe it was even today, a sanitation driver was down in downtown Clearwater, and he was backing up the truck, and a car failed to pay attention and struck him as well.
Oh, wow.
And so
both similar scenarios.
Yeah, very similar. And people have to realize that there is a law in Florida. It's called the move over law. And often people think that's just having to do with police that are stopped at the side of the road. But really, you have a legal obligation to either move over to the next lane or slow down significantly if there is a police car or even a tow truck or any utility vehicle or garbage truck, any types of those vehicles that may be on the side of the road. You have a legal duty to move over to avoid situations that we just talked about, 2 things that tragically could have been avoided if people were just following the law.
Yeah, going off what Matt said there, attentive drivers, drive defensively, because you see a construction worker on the side of the road, and especially on I-4, how crazy I-4 is, right?
Yeah.
You're going to want to move over to the next lane to avoid that at all costs, because there's no way anyone should be driving over 30 miles per hour, going past those construction workers, because that's just a recipe for disaster.
Thankfully, in recent years, I think I've seen more signage, informing people of the law. I don't think I saw that much years ago, but now you do see it a bit more. So I hope people are paying attention to that, because I know we've probably seen countless cases of disabled vehicles or Good Samaritans who stop to help someone on the side of the road fix a tire or something like that, and then they're tragically killed by someone who unfortunately hit them on the side of the road. So it's for everybody's safety, and it is the law.
Yeah, and going off of people who have been tragically killed, obviously in the personal injury world, there is such thing as wrongful death lawsuits, and because it is a wrongful death lawsuit, there's different damages that you can recover, and there's different people who can recover. So Matt, do you want to kind of
Sure, I'll touch base on that just a little bit. Yeah, if a loved one is killed because of the negligence of somebody else, the surviving spouse is entitled to compensation. Also, the minor children are entitled to compensation. And children that are, I think it's the age 25, 23, yes, are still entitled to compensation for the loss of their loved one. The really crazy thing about it all is that if it's medical malpractice, that's not the case. If there is no surviving spouse, there is no claim, even though the negligence was clearly the cause for the wrongful death of the person. It's a little caveat in the law that no people really pay attention to too much until it affects them.
Right.
And it really can have devastating impact on a family.
Sure. And it looks like we actually have our first caller tonight. How's it going?
Hi, how are you?
Good. Is there a question you have for us?
So I'm considering putting my mother in a nursing home, and I have a lot of worries because of just the horror stories I've heard, but regarding just negligence or abuse. And I really can't take care of her at home, so this is really my only option. Now, is there anything I should be looking out for when I visit her? And at what point do I take the next step of contacting you regarding any negligence? Do I let it go for, wait a couple of times or until it gets more serious, or do I need actual proof?
Sure. Well, in order to bring a claim for anything, there has to be proof. It's a little premature until the actual negligence happens. But, with nursing homes in Florida, I mean, let's be honest.
Live in the state.
I was about to say that, Matt. I'm just going to be blunt here. There's a lot of elderly people in Florida, right?
Right.
And because of that, the Florida legislature has actually provided a Bill of Rights for nursing home residents in order to protect them, because there have been instances like that where a person in the home has been abused, neglected, and due to negligence of the workers of the nursing home. And I'm not saying that they're all negligent, obviously, but oftentimes there is that case because elderly people do need a little bit more care, a little bit more attention, right? So because of that, the Florida legislature has these Bill of Rights. So in any nursing home, residents have the option. I just pulled it up here on Google and you can find it. They have the right to participate in social, religious, and community activities, the right to manage their own financial affairs, the right to examine upon reasonable request the results of the most recent inspection of the facility, the right to present grievances. But most importantly, they have the right to
be treated with the respect.
Treated
really
with
what
respect it is. And getting prompt and good medical treatment when it's needed. So in regards to that, that's something every loved one or every person who has a loved one in a nursing home should look out for every time they go visit and see if one of these rights are violated, because absolutely, if there is an instance like that, there is a chance for bringing a claim.
Right. And family members should have a copy of that Bill of Rights and have them with them. So every time they do visit their loved one in a nursing home, they can check those Bills of Rights to make sure that they're being followed. And if they're not being followed, that's the time that you need to let administration know.
Absolutely.
Put it in writing, let them know. And then if the administration ignores it or if it continues and there's damages because of the violation of the statement of the Bill of Rights, then the family member should consult with an attorney, not only to protect their family member, but rather also to protect all the other family members and all the other residents that are in the nursing home.
Well, I hope that answered your question for you. I know that was long-winded, so.
Yes, it did. Thank you so much.
Good luck to you.
A little bit more peace of mind. Thank you so much.
Thank you for calling.
So, yeah, I mean, thankfully, you're right, Matt. The elderly in Florida are well protected with that client bill of or resident bill of rights, excuse me.
Bill of Rights, yeah.
And
but that's not the legislatures that did that. It was plaintiffs' attorneys who did that. It was because of all the injustice that was going on that finally they stepped up and they listened to the silent sufferers in nursing homes.
And if you do see something in a nursing home facility, you're right, Matt. You should definitely bring it to the administration's attention or an attorney's attention, because sometimes it might not just be that one resident.
Right.
It's likely more than one at that facility.
And it may not be your loved one. It may be you saw something from another resident. It'd be good to, go up to that resident and ask them who their family contact is, and then reach out to them.
Absolutely. And it looks like we have another caller, actually. Hey, how's it going?
Good. How are you?
Good. You have a question for us?
I do. I was in an accident and someone hit my car, but then left the scene of the accident. Is there anything I can do or any advice you can give?
Well, I'll let Jacqueline take that one.
Right, sure. So I definitely recommend that you call an attorney like ourselves, because there are lots of things that you can do and that we can look into. First, obviously, there's investigation that could occur to try to locate that driver. It's not always fruitful. Sometimes they do get away. But the good thing about it is we're a no-fault state. I don't know if that's still good or not, but we do have PIP coverage. So your own auto policy, first and foremost, will provide you that PIP coverage that will take care of your initial medical bills and treatment, assuming that you're injured. And if you are, then that will cover your ER visit, urgent care, and until that $10,000 exhausts. Beyond that, you would want to take a look at your own policy to see if you have what's called coverage, or uninsured motorist coverage, which would kick in the event that driver that hit you couldn't be located. So if you had that on your coverage and in fact that person did get away and it was a true hit and run, then your insurance company would then step into the shoes of that at-fault driver and provide whatever the limits of your coverage is. It could be 10, 25, whatever your policy has. Now, unfortunately, if you did not have that coverage, then it may be a scenario where you are limited to the PIP coverage. So it would be very important to reach out to us and to allow us to get the investigation started. The sooner the better. If there's cameras around in the area, there's businesses, rarely, but sometimes the intersection cameras are recording. Sometimes those are live feeds, but every now and then you might get a recording to see if we can locate that driver. There's witnesses. So you do have options. It's not, everything is not all lost.
Right. But Jacqueline, that's a perfect example of why uninsured motorist coverage is so important. I mean, too often times we hear people that come into our office saying, "Oh yeah, I'm fine. I got full coverage." Full coverage does not mean anything. It does not mean that you have uninsured motorist coverage. Check your policy today before an accident to make sure that you do have uninsured motorist coverage. Not only does it apply when the at-fault driver doesn't have enough insurance, but as Jacqueline just said, it applies in these hit and runs or these phantom vehicle situations. We're seeing a lot more of those nowadays. There are people that may not be here legally that are driving, and they flee the scene, because they're scared and they leave the scene. I had a case where just a lady just got scared, and we tracked her down, but she wasn't impaired. She wasn't alcohol or anything like that. She just got scared because she caused a wreck, and she went home and eventually reached out to the police officer who did the investigation.
Wow. That's rare.
Yeah, she just said she got scared and she felt bad for leaving. So,
well, thankfully for trying to prove accidents, people who do desert the scene, it's a lot easier to prove who was at fault, right?
Right.
So
that fact is helpful at times.
So, again, I just want to give the listeners our information on how to call and ask us legal questions. You can call us locally at 727-441-3000. Again, that is 727-441-3000. You can also call us toll free at 1-866-826-1340. Again, that's 1-866-826-1340.
Yeah, and too many times we see these crashes that occur that the at-fault driver didn't have any liability coverage. And yes, there's PIP coverage available, but PIP only pays 80% of the medical bills. Who pays the other 20%? Well, and they only pay 60% of lost wages. Who pays the other 40%?
Right.
Without uninsured motorist coverage, you're kind of stuck. And so that's why uninsured motorist coverage is so important.
And just like you said, most people, a lot of people come in and say, "Oh, I've got full coverage." So if you're one of those people who think you have full coverage, I encourage you to check your policy today, because we find that our clients tend to think that, and they are the ones that don't have So just give a glance at your policy. A lot of times you can have them on the mobile app on your phone. Take a look, pull it out, and see what you have. And if you don't, I encourage you to add as much as you can afford.
Yeah, and our offices at Parent Caulfield, Dade, Illinois, are always happy to review your insurance policy.
Absolutely.
Before the crash, to protect you from more injuries after being hurt in a crash.
Yeah, and you had mentioned it's uninsured or underinsured motorist coverage, because we often see the scenario, right, Matt, where there's injuries, there's damages that are far in excess of what the bodily injury limits cover, right? So oftentimes, that's when then your uninsured or underinsured motorist coverage kicks in. Right. So, if you want to explain to that a little bit more to the listeners on who and how one gets access to that coverage, right?
Right. You need to make a claim under the at-fault driver's bodily injury liability coverage first, if there is any. In the state of Florida right now, there's no legal requirement to carry bodily injury liability coverage. People think that there is, because in many states there are, but in Florida there's not. We've been fighting for years trying to get Tallahassee to do that.
Right. Almost got it.
Instead of playing other games up there right now. But we've been trying for years to try to get mandatory bodily injury liability coverage. But if you're able to get the at-fault driver's bodily injury liability coverage, and it's important to also look into the at-fault owner's bodily injury liability coverage. Most people don't think of that, but it's also important to look at the owner and the driver to see if there's different liability coverages. But once you've exhausted the underlying coverage, then you can proceed with the underinsured motorist claim. It's really I call it putting a puzzle piece together. You have to get all those pieces together to show the insurance companies the true picture of the impact that a crash has on you.
And if you're in someone else's vehicle at the time of the crash, you might qualify under their underinsured motorist coverage and your own. So like Matt said, there's so many different layers that have to be explored and peeled back. So that's why it's good to reach out to lawyers like us at Parent Caulfield, April, and Noyes.
But if you have a question right now, you can just give us a call right now. We're able to answer the call.
Yep, you can call us again at 727-441-3000.
I had a perfect example. I had a client earlier this week. It's kind of workers' comp question as well. She was walking to her car, and as she was walking to her car after working, she got hit by a car as she was crossing the street. The at-fault driver and she broke her shoulder, I think it was, and broke her ribs.
In the crosswalk?
She was in the crosswalk.
Okay.
But unfortunately, the at-fault driver only had $10,000 worth of bodily injury liability coverage, and she did not carry uninsured motorist, even though she thought she had full coverage.
Right.
And so the liability certainly will pay the $10,000, but that's far too low for the damages that she's had.
Yeah, and trust us out there, we have our fair share of nightmare scenarios that we come across far too often when it deals with uninsured or underinsured motorist coverage. But
right, and we can take this call, but I wanted also to go back to that scenario because I want to talk about the workers' comp aspect of that.
Sure, and Matt said we have another call on the line. Hey, caller, how's it going?
Hi, caller.
Hey, how you doing? Hey, I've got a question. So how does the law read? Let's just say, for example, I am driving somebody else's car and they have inadequate insurance and I'm involved in an accident, and it may or may not be my fault, but what exposure do I have? And would my insurance, if I have adequate insurance, cover me if I'm involved in an accident driving somebody else's car?
Well, that's a great question you got there, a little two-parter. I'll give one to Matt here for him to answer.
All right, I'll answer the easy one. I'll let Jacqueline answer the more difficult one. If you are driving somebody else's car with their permission, your liability insurance will protect you for any negligence that you may have caused. If you did not have liability insurance and only the owner had liability insurance or didn't even have liability insurance, you and the owner would be personally liable for any damages that were a result of any negligence that you may have had.
Right.
Yeah, it's called the dangerous instrumentality doctrine, right, Matt?
That's right.
Right. And so the second part of your question, if I'm understanding correctly, is if you're injured or you're hurt and you're driving in someone else's car, is that right?
No. It's basically if I'm driving somebody else's car and there's an accident, okay, regardless of whether I'm at fault or not,
right.
My question would be my exposure, if they had inadequate insurance, would my insurance company, if I have more than adequate, whether I have uninsured motorists or not, would it come into effect?
Right. So typically speaking, your insurance is going to cover you as the driver. Then if that's insufficient, the host vehicle's coverage could kick in depending on, the circumstances. So if you had adequate, coverage on your vehicle and it covers your damages and on your own policy, then you may never ever get to tap into, that host vehicle. But usually the host vehicle's uninsured motorist coverage is going to be primary. So the person that owns that vehicle's coverage, if they have UM, is going to be first and foremost.
But that's only if he didn't cause the crash.
If he didn't cause the crash,
if
right.
you cause the crash,
and it's your own policy is going to take care of those damages.
And uninsured motorists would not come into play if you caused the crash.
If you're at fault. So I guess your question was regardless of the fault, but unfortunately that is important to know who's at fault for the accident to answer the question.
Well, the example would be if I'm driving from here to Atlanta and I'm riding in my friend's car and now we switched drivers and now I am driving his car. Right. So that's what my concern would be. So now I'm suddenly the driver.
Sure.
Let's just say he has minimal insurance coverage, but I have more than adequate.
Right. Yours would be there. Yeah. You would go through your own.
Right. If you caused the crash, then your liability insurance and his liability insurance would protect you. If someone else caused the crash, then your uninsured and his uninsured and the at-fault driver's liability coverage would come into impact. So it depends on responsibility for the crash.
Right.
Was that helpful?
Yeah. How versed are you guys with diminished value law?
We do handle those claims as well.
Yeah.
Shoot, what's your question?
Well, I'll give you an example. I have a friend of mine that was recently involved in an accident, and it was on a 6-lane highway, and someone meandered in front of him. So that person swerved to avoid an accident, but still clipped the rear of the car. Interestingly enough, there was $10,000 damage to the one car, my friend's, and there was about $10,000 damage to the other one. But when the police arrived on the scene, there was no police report filed, and nobody was charged. But both cars were damaged. I mean, they were drivable away from the scene of the accident. So the person that, since nobody was charged, so the question is, does diminished value come into play here? Because basically this person got in front of my friend, he struck them, and now she's like, well, what do I do? Because now my car's not worth what it was before the accident. There's a lost value. How do I get indemnified for that?
Well, I mean, that's a great question right there, because oftentimes we deal with diminished value in that exact scenario where the fault hasn't been determined. There's property damage adjusters that are combating against one another from different insurance companies as to who caused the accident. But diminished value is entirely contingent upon how much property damage is left, right, after the property damage
limits,
and the policy limits of the property damage coverage. So, just like how it is in the UM or the BI field, it's you got to look to see what's available after the property damage
once the car is repaired. Right.
So,
Right. And I think you made a good point. You said nobody was ticketed. That doesn't matter when we're talking about diminished value, or because it's an independent investigation to see who's at fault for the crash.
Mm-hmm.
And if the other person was at fault for the crash and there is adequate property damage coverage available after your car is fixed, then certainly you would be entitled to a diminished value claim. Typically, the vehicle has to be a newer vehicle because, as we all know, as soon as you drive the vehicle off the lot, it loses all kinds of money and it depreciates so quickly.
And oftentimes, too, with diminished value cases, you can always ask for that, but I highly, highly recommend to anyone who's dealing with the property damage adjuster and a release for property damage after they've paid, look to see before you sign away anything whether or not it includes relinquishing a diminished value claim or a loss of use claim.
Right. And a lot of times you need experts to assist with the diminished value claim because the insurance companies will undervalue that. If you try to submit it yourself and say, hey, my car was worth this and now I think it's worth less, they're usually going to lowball you. So what we tend to do is retain experts who can value out the car as far as the damage that was sustained and what the actual true value of the car is now. And you can submit those reports to try to get the diminished value under the other driver's policy or even under your own collision coverage.
Well, I hope that answered your question.
Thank you.
Okay, well, that was next. You just brought that up. So basically, if they have inadequate coverage, would my collision, full comp collision cover that, or would it fall under uninsured motorist?
It would not fall under uninsured motorist, and it would also not fall under your comp and collision. A diminished value claim is solely a claim against the at-fault driver. It's to be too legal.
Under the property damage.
Yeah,
right.
to be try to avoid legally. It's a third-party claim as opposed to a first-party claim.
Okay. Because my understanding is in Georgia they have a first party and a third party statute on the book.
There may be every state is different when it comes to that. So I wouldn't be too surprised if Georgia was different than
Probably
Florida.
true. Yeah.
So, but thank you for listening and thank you for calling. We really do appreciate you asking the questions, so we have an opportunity to answer them. So thank you very much.
Good question.
Yep. And at this time, we're going to
Keep up the good work.
Thank you.
Absolutely. At this time, we're going to take a quick 2-minute break. Again, before we leave, I'll give you the call. It's 727-441-3000 if you want to call in, and talk to you soon.
This is the Tan Talk Radio Network.
In 1955, the law firm now known as Pernick, Caulfield, Averill, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Pernick, Caulfield, Averill, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the Tan Talk Radio Network.
And welcome back. This is FLA Law with the attorneys over at Pernick, Caulfield, Averill, and Noyes, the live call-in radio show where you can ask us with your legal questions, and we'll do our very best to answer them. Before we get to the next caller, I just want to give the phone number to call in one more time. It's 727-441-3000. All right, it looks like we have a caller on the line. Caller, how's it going?
Hi,
Hi, it's going pretty good. I had a quick question. I was in an accident while I was making a delivery for my job. Now, workers' comp is paying for my bills, but can I settle my auto claim? And if so, what happens to my work comp claim?
That's a great question, and oftentimes accidents happen when you're on the job. So, Jacqueline, do you want to answer that for the caller?
Sure, I'll take that question. So, yes, the answer to your question is yes, you can settle both claims. They're two separate claims. The issue that you want to pay attention, though, is with work comp, there may be a resignation that's required if you settle. So it depends on how much you like your job and whether you want to actually consider resolving that claim with in a lump sum, because most employers unfortunately will require a release and resignation if you decided to settle that work comp claim. And then if you do settle, that lump sum gets rolled into what's called a lien, and that money that you got, sometimes your lawyer can be savvy enough to argue that shouldn't be included, but most times what you got in that lump sum will be added into whatever medical bills they've been paying for you, and then they will put a lien on that auto claim against the driver that hit you, and whatever that amount could be, whatever that amount is can be negotiated. So our offices could assist in trying to get that lien reduced so that it doesn't take so much out of the auto claim. But to answer your question in short, yes, you have claims for both. You can settle both, but there's some, important factors to consider whether you want to actually settle the work comp claim and how that lien will be handled with the auto claim.
And I think that's why it's good to have an attorney who understands both the auto accident aspect and the workers' comp aspect. I work a lot with attorneys that handle the auto part, and I handle the workers' compensation part for them because they aren't as savvy in workers' comp as we are.
Right.
And so we know to work together to maximize the injured person's benefits, both on the auto case and on the workers' comp. The problem is there's some attorneys that say they do auto cases and then they don't know anything about the workers' comp, and then it has dramatic impact once the auto case is settled or if the workers' comp case is settled first. Mm-hmm. I always try to settle the auto case first if that's possible before you settle the workers' comp claim. Auto cases have to get settled one way or the other,
right,
while workers' comp cases can stay open if we can't agree to a settlement.
Yeah, and Jacqueline mentioned about settlement and workers' comp case and how it often comes with a voluntary resignation.
Mm-hmm.
And personally, I haven't seen an instance where it has not come with a resignation from your job. It's very rare in those scenarios.
Usually when they switch carriers or something along those lines, if the employer has a new insurance company, then a lot of times they'll let you get by without a resignation, but it's very rare.
And I've had a few situations, though, where the employer loved the employee so much that they said, listen, I don't care. I'll hire them back the next day, and so, but you're right, Jacqueline. Most of the time it's only when the carrier switches and they don't want to have to pay for a new work comp injury from the same employer.
So, caller, are you still there? Did that answer your question?
It did. I appreciate you guys so much. Thank you.
Absolutely. Anytime. Thank you for calling.
So,
and that opens the door for the workers' comp that I wanted to go back to because really you see the oddest battles in workers' compensation. In this situation, her employer is saying, listen, it's not work comp. She was punched. She was off the clock. She already clocked out and was walking to her car. And some people would believe that that's the case. As soon as you punch in is when workers' comp starts, and as soon as you punch out is when it ends. But that's not the law.
Right.
The law is that as long as you are furthering your employer's activities, you are entitled to workers' comp benefits. If you arrive on their premises, workers' comp starts ticking as soon as you get into their parking lot and as soon as you pull out of their parking lot.
And kind of parlaying off that a little bit, I often see scenarios in work comp where an employee is at a hotel, maybe overnight on business or something, because of their job. If you get hurt there, work comp can still be utilized because you were not at that hotel, but for the fact that you're on a way for a business trip.
Exactly.
So,
The traveling employee exception. That's exactly true.
And Jacqueline, I kind of keeping in the work comp world here, and I kind of want to talk a little bit about exposure cases and the problems that come with those. Because,
you guys have fun.
Yeah, because I think it's noteworthy. Yeah, I think it's noteworthy for the listeners to understand that those are the most difficult cases to prove in work comp.
Mm-hmm. So, yeah, I mean, every now and then we'll get cases like that where people have been exposed to some sort of extreme circumstance, whether it be fumes or some sort of toxicity in the environment. And those can be difficult to prove because, there has to be authorized treating physician, for one, that will agree that came out of the course and scope of your employment. And so that it is challenging. Those tend to be the cases that I don't always agree to take because they can be difficult. But a lot of times, I think there's a special standard. If I'm not mistaken,
there's a higher standard of proof that you need to do in exposure cases. It's tough enough in a regular workers' comp case to prove major contributing cause, but in exposure cases, you have to prove with clear and convincing evidence.
Right, but it doesn't mean that there's no claim. So, depending on the circumstances, you can obviously give us a call so that we can look over the facts and see how it occurred. Sometimes what you think might be exposure could be something different, like repetitive motion or something like that. In those cases, a little bit more easier to prove. So.
Well, we all delved through and lived through COVID, and there was a lot of COVID exposure workers' comp case law that was being generated.
Oh, yeah.
Yeah, if there's any questions about that, absolutely feel free to give us a call tomorrow at their office. You can find us on usalaw.com. Our phone number is 727-796-8282. That's the office line for us at Parent Caulfield. But for the callers out there, if you want your legal question answered, you can call us again at 727-441-3000. So kind of going back into the personal injury field as opposed to work comp, although they do go hand in hand oftentimes. It is spring break, so I think it is still spring break.
Probably.
My son hasn't been on spring break yet. We at the Catholic
through the rest of the month.
So we at the Catholic high schools don't get it off until the week after Easter.
Oh, okay.
So we still have 3 more weeks till we get spring break.
Well, it's a little chilly, so whoever's here for spring break, I apologize. The beach isn't as nice.
I think they're still loving it though.
But well, Jacqueline, now that people are on spring break. And there's a lot of people going into stores, especially on the beach area.
Sure.
Oftentimes there are some substances on the ground, some slip and falls essentially are very common this time of year. When that happens, do you have any tips or advices on what the listeners can do to properly document and to help their case if they have one?
Oh, absolutely. Yeah. So obviously, proving what it is that you slipped on is going to be key. A lot of times, I think we touched on this one show before, people are embarrassed or they're with their friends. They don't, want people to know that they fell, or their instinct is just to kind of get up and shake it off. Unfortunately, that's not the best way to approach it. You want to take pictures. You want to document what you saw, whether it's sand, water, mud streaks. The way it looks is actually very key to your case, believe it or not, because you have to prove what's called notice. And they have to have known or should have known that whatever it is that caused you to fall was there and existed long enough that they should have seen it and remedied it before you fell on it. And so the way it looks, if it's tracked through, if it's muddy, you see footprints or cart marks through it, that can actually help because it shows that it had been there in such a state for so long that people were walking through it, tracking through it, and that they should have known about it. So photos, documentation, get an incident report done, report it to someone there in management. I think that's probably the best advice I would give.
Those are some good tips, Jacqueline. Actually, looks like we have another caller on the line.
Awesome.
Caller, how's it going?
Oh, just dropped.
Oh, well, we love
Bobby, how's it going?
Please call back. Please call back.
whoever that was. Feel free to call back. We're here for another.
We're still here. Call us back.
Yep, another 10 minutes. You can call us at 727-441-3000 if it's easier for you that way. I don't know how you tried before. Maybe the toll-free number, 1-866-826-1340 for those interested.
Right. We were talking about slip and falls and trip and falls. It is important that that caller or listeners understand that just because you got hurt at the premises doesn't make the property owner automatically responsible.
Mm-hmm.
You still have a burden to prove that they did something wrong to cause you to get hurt, or they failed to do something right to cause you to get hurt.
And the burden of proof is always on the plaintiffs. And it looks like we actually got that caller back.
Oh, good.
Or at least maybe
Hey,
a
At
caller.
least I hope so. Caller, are you there?
Yes, I'm there. Sorry, I have some misbehaving kids in the car right now.
Oh.
No problem.
I was calling because I had an accident a few years ago and herniated a disc in my neck. I underwent treatment and started feeling fine, so I stopped the treatment. But then last month I got in another accident, so I went back to treatment. Can my prior accident have anything to do with this accident, or how would I proceed?
Well, I'll let Matt answer that, because
All right.
that has all to do with prior accidents and how they can affect a new accident
Right.
and prior injuries.
Right. Is the first accident, was that a claim made against the insurance company?
Sorry, can you repeat that?
Was the first accident, was that claim still open?
No, I think it closed when I stopped the treatment.
Okay. Under the PIP, if you're involved in a subsequent accident, the insurance company for that accident is responsible for anything that is reasonable, necessary, and related to that accident.
Mm-hmm.
Now, if you have an underlying condition like a pre-existing condition, they are still responsible for any aggravation of the underlying condition. Now, in some situations, in your situation, it may be that the first accident is partially responsible for treatment after the second accident, and the second accident is also responsible for treatment. It really depends on what the doctor says. That's a medical question as to the causation of your need for treatment.
Mm-hmm.
And if there is a lapse in time from the last time you treated for that first accident to this new accident, definitely make it known when you go speak to an attorney, or if you haven't done so already, because I highly recommend that.
Mm-hmm.
Yeah, and absolutely tell your doctor, because that documentation is going to be crucial in order to get any compensation for the subsequent accident.
Right, and also I've had people think that they're not entitled to compensation for a recent accident because they had pre-existing. Well, that's not the case. That's not the case at all.
Especially if you were feeling better. If you had you treated for that first accident and it had kind of helped and you were done, like you said, you had stopped treating. And then this new accident kind of brought you all back to where you were before and made your pain worse. And that's, obviously an aggravation. And we think it's definitely something you should still pursue.
Hopefully that answers your question, caller.
Yes, thank you so much.
All right, go back, take care of those kids, all right? Thank you for calling.
So we got about 5 minutes left here, and I'll give the listeners out there the phone number as well in order to get those last minute questions in. Our phone number is 727-441-3000 in order to give us any legal questions you may have. Use our knowledge, use our experience. We're here to help.
I remember when we used to do the TV show, it was the last 5 minutes where all the calls were coming in. And so we always were willing to stay afterwards and answer the questions, even if we were no longer on the air.
We might get booted from the next radio show, but I mean,
you can call our office at that point.
That's right. Day, right?
We can call you back too.
Yeah, 727-796-8282 is our office number for those who can't call us today and want to get our opinion on things tomorrow. So while we have a few minutes left and waiting on a caller, there was other news that came out of Clearwater Beach, sad news that happened at a surf shop there on Clearwater Beach, and there was actually a shooting that was inside. Crazy. I mean, we were talking about spring break earlier, and that's one of the sad things that comes with it, right? Mm-hmm. And there was actually one victim taken to Morton Plant. I think he was okay. I'm not entirely sure whether or not they passed, but I think he was okay. Yeah. Injured, so
they finally caught, who did it. I know that much.
Yeah. But that got me thinking, Jacqueline, a little bit about negligent security. Mm-hmm. And if you can hold a business or a premises, apartment complex liable for not having the proper safety measures in place. I know this was a surf shop store, but it could be a little bit different if it was a bar that was known for having reckless patrons or bar fights and things of that nature, right? Right.
Yeah, so it could be different in the circumstances involving the fact that it was a surf shop, but you're right. So depending on the area, if it's a high crime area or if it's known to be an establishment that has these kind of problems where there's, people that loiter and they cause issues or they have fights and there's frequent crime calls, police have to come out there frequently. And the establishment is aware of this, but they haven't taken the steps to provide adequate security. It could be argued that something like this, an assault or an attack, or a shooting is foreseeable. And foreseeability is kind of key in these negligent security cases. And it can't be a situation where, where there's just absolutely nothing that could have predicted something like that. But when there's history and there is a pattern of this type of, incidents occurring, and they fail to have, someone at the door, like a bouncer, or there's no one patrolling the apartment complex and those type of situations, or there's poor lighting, or there's no security gates. A lot of those factors can play into whether or not there's a claim for negligent security. So it depends on where it happens and the facts surrounding the area.
Well, it also depends on when it happens, because right now they're trying to pass a law.
It may change tomorrow.
Yes, they're trying to pass a law to take away the rights of people that get hurt.
Yeah.
Now they say it's for the protection of the business owners and such like that. But I personally, I think it should be more of a balancing act. Don't take away the rights. Hold the business owners who are responsible. Don't formulate a law that lets every businessman get off if they could have or should have done something to prevent
especially when it's
injury.
Foreseeable.
Yes.
Yeah, and going off what Matt said, for those who aren't aware and that are listening, there's this thing in the Florida legislature right now called the tort reform. If you haven't heard of it,
it's about desserts, isn't it?
Yeah.
If only it were.
If only. I highly suggest those who are curious and that are interested, take the time, go on Google, do your research, see how it could potentially affect you, because I'll be honest, some people just don't expect when an injury or a bad situation happens in which they're suffering. So,
but if one does happen and you need help from a lawyer, give us a call at Pernick, Caulfield, Averill, and Noyce. We're at usalaw.com or at 727-796-8282.
All right, signing off. Jacqueline, anything?
No, I just thank you for all your calls, and we'll be here next Tuesday, same time, 5:00.
All right.
Bye-bye now.
Thanks, everyone.
WTAN, Clearwater.
FM 106.1.
WDCF, Dade City.
FM 102.3.
WZHR, Zephyrhills.
FM 104.3.
Listen.
Hey, Tampa Bay, here's your 30-second weather check-in. Tonight we'll be looking at mainly clear skies with a low of 59, with east winds 10 to 15 miles per hour. Tomorrow looking a little warmer at a high of 80, with mainly sunny skies. And